There, now I turned it on. Thanks for reminding me.
Um, okay, say it again, which is the site?
Housing providers for a better Minneapolis and St. Paul.
I'll send a link on the group chat.
Thank you. You're very efficient.
I'm worried that our presenter isn't here.
Got 2 minutes.
It's
How's your shoulder?
better, thank you.
That's good.
I did not have a good day though, so.
I'm sorry. I'll mute again.
I'm texting our presenter. See what he says. Oh, he's in the waiting room. Okay. Hey, Larry, you can disregard my text message. We'll give it a couple minutes here and see if we get a few more people, and then we'll go over a couple market stats and let Larry teach us all about contracts for deed. Hey, Donna.
Hey,
You look cold.
I'm freezing. Well, we had 40 people register tonight, and usually we'll have a little bit of an atrophy, not everybody will show up, but I'd like to give it a minute or two and see if we can get a few more so we don't have to go over it again.
Hello, Carrie. Gary Jensen here.
Hi, how are you?
Super.
Well, I guess I could start in on some market stats while we're waiting for people. Christy, can you do the admitting people?
Yes, I will.
Okay, I gotta find my I think it's behind the screen. Can you see the state of the real estate market slide, everybody?
Yes.
Yeah.
Yes.
Okay, all right, great. Then I'll run through this quick. I won't linger on it too long because I know we're all anxious to hear Larry, so
All right. So no surprise here. Fed's interest rates are still kind of between 7 and 7.5. This is on a 30-year fixed rate mortgage in the United States for an owner occupant, primarily single family here. 15-year is between 6.5. No surprise there. All right. Here we have, now I want to be really, really, really clear. These stats are only for 2 to 4 unit properties. Christy and I hand calculate these stats. They don't exist anywhere else. So when you hear single family home stats in the media, that is for condos, single family homes, and townhouses. This is actually 2 to 4 units in the Twin Cities. So the blue line here is the number of active listings over the last 2 years, and the reds are the solds by month. You can see, as always, like we do every month, that June, July, August, we have this big wave of properties up, and I do that every month too, don't I? We have this big giant wave of properties coming on the market, but sales for the most part are pretty constant throughout the year on duplexes, triplexes, and fourplexes. So that wave, late spring of 2021, again, June, July, August, you have more competition if you're thinking of selling your duplex. You'll have less competition back up here January, February, March than you will if you kind of dawdle and get your painting done by June. But the number of transactions doesn't jump up in the same ratio that the number of listings does. We didn't have quite the same spike this year. We didn't have as much inventory. Sales were actually in some months up slightly, but comparatively relatively constant. So, all right. This is the 7-county metro area. So we've extrapolated Minneapolis and St. Paul here, and well, not extrapolated, but included and brought in counties like Anoka, Washington, Carver, Scott, Dakota, etc. And the numbers are pretty comparable. You get a little bit of a bump in the numbers, but not much. There just isn't that much suburban multifamily inventory. Same, red is the 7-county. You can see it's just slightly ahead of the blue, which is Minneapolis and St. Paul, number of active listings by month. Number of solds. Again, a little bit of a dip in February. That is going to be sales that happened in December, but not that big swell of sales that everybody expects. And if you want to call this here a swell, that's February, March, April, which means those contracts were written on those properties 1 to 2 months prior. So we're seeing activity from the rearview mirror. Here's the percentage of active listings to sold listings. So the 34% on this red line is 34% of all multifamily on the market sold in November. That's for the 7-county metro. 32% of the active listings, Minneapolis, St. Paul. It seems down, but if we go back to November of last year, we're actually up 3% in Minneapolis and St. Paul, and we're up 1% in the 7-county metro area. So it's not as doom and gloom as we tell ourselves all the time. It's pretty comparable year over year. Here we go, average sales price. You can see it's just always an up and down. We just don't have thousands of duplexes that sell every month. So one big sale can change the average for the month. I think it's important to look kind of like where the majority of them fall. And you can see kind of May, June, July, August, September kind of in there. We're kind of between the $398 to $415 for an average sale price for 2 to 4 unit properties in the metro during those months. We'll have annual stats here probably the first week of January. It usually takes the MLS 10 days to get all data completed from the preceding month. days on market. So the longer inventory is on the market, the less of a seller's market it is. And you can see we're still below 30 days in number of days on the market in November. And if we go to month's supply of inventory, I think that's the next slide. Nope, I'm ahead of myself. This is cumulative days. So if they canceled and relisted, if they've been on the market more than once, this is their total number of days. Not that much higher than the previous slide. Here we go, months of inventory. So remember, a seller's market is anything pretty much 4 months and below, and a buyer's market is anything above that. We're at a 3-month supply, so still a seller's market. And we've been at 3 months supply previously. Last December, we had hardly any inventory at all. But we really haven't seen that big fluctuation in terms of inventory yet. Where if buyers have more to choose from, the way it impacts sellers is the buyers have more options, so they're able to negotiate better terms for themselves. And number of showings, which is always the canary in the coal mine. You can't have a sale unless people have looked at the property. And you can see that we had in the 7-county metro area in November, 1,826 showings. If we go back to November of last year, it was actually 1,698. So actually showings are up. And if we look at the Minneapolis, St. Paul, 1,456 in November of this year, and last year, 1,345. So I kind of think maybe people have the opportunity to look at more properties before they make a decision. But there's still activity out there. That's the moral of the story. And this is the number of showings by price point. As you can see, the gray line, which is anything under 400,000, has the biggest showing activity. The blue line is anything priced between 400,000 and 500,000. You can see that that's fallen off here in November, but it's not that different from December of last year. Red is 500,000 to 700,000. And basically the moral of the story is the higher the price, the fewer the showings. So does anybody have any questions from that 30,000 foot market view? If not, I'm going to introduce our guest. So Larry came recommended to me from my real estate attorney as the guy who does all the continuing education for contracts for deed for attorneys. So that would make you an expert, Larry. Are you there?
I'm here. I'm here. I was just trying to hold back my my throat when you said expert. Yeah, no, I do a lot of continuing the legal education, and I write articles and for lawyers and stuff like that. So, and I try and keep up on the area. I may not necessarily be that familiar with what's going on in the marketplace. In fact, I'm probably not that familiar because I don't do a lot of garden variety contract for deed transactions myself, but it's a small area of the law, and I guess I'm the guy who knows it, although it may be. One question I had before we get into this, are folks here, and maybe you explained it to me before, but it sounds like most of this is 4 units or less, or people.
Yep, most of the people here own buildings that have 2 to 4 units. They're smaller landlords, which is the majority of landlords in the United States.
Yeah.
And I'm guessing they've probably owned their property a pretty long time. So they're facing some, if they would choose to sell, they're facing some pretty serious tax consequences.
Right.
And of course, with interest rates being so high, one of the advantages of a contract for deed is you might be able to get a pretty good return on your money and never have to deal with a tenant.
Right. Yeah. And my other question was, are any of these folks, are they also occupants too, or do they, they occupy one of the 4 units, they rent to themselves, or is that not very typical at all.
That's pretty typical, but I don't know about this group. They could raise their hand or unmute themselves and tell you if they own or occupy.
It may have, there's some, and I'll talk about this later on, about some potential changes in the law that may or may not be relevant to depending upon the situation. But let me back off and talk about contracts for deed generally. I mean, I'm glad to just answer questions if I can simply kind of talk about contracts for deed generally and explain what they are and how they work. But I want people should feel free to jump in at any time if they have questions. That's okay.
Yeah, give an overview. Did you have a PowerPoint? I made it so you can share your screen if you do.
No, actually, I didn't. I didn't do a PowerPoint. Most of my
Okay.
PowerPoints are probably too technical for.
Okay.
They're for lawyers and such. But so basically, a contract for deed is what we call it here in Minnesota. In other states, they sometimes call it an installment land contracts or installment sales contracts. But it's basically a form of seller financing. The seller finances the purchase of the property from the buyer. And typically the seller may have owned it for quite a long time and then they will sell it on a contract. Now, let me ask, do the folks here have mortgages on their property typically? Is that, or do some of them own them outright? And
Can somebody please feel free to unmute yourself. This is an interactive thing, so does everybody own their property free and clear? Or you got mortgages or small mortgages or?
I have both.
okay, so you own some that are subject to existing mortgages and some are you own free and clear. Okay.
Yes.
Well, we used to have a lot more contracts for deed back when I was much younger, back in even before I started practicing law in the 60s and the 70s. But what has, to a certain extent, limits the use of contracts for deed is that starting in the 70s and now in almost all cases, especially with conventional loans, they have what are called, the mortgages have what are called due on sale clauses. And basically a due on sale clause is a provision in the mortgage. Again, this is, we're talking about a mortgage. Someone, the lender makes a loan, and in addition to requiring, the monthly payments, and you carry insurance and you pay property taxes, virtually all mortgages now contain what are called due on sale clauses, meaning that, kind of like what it says, the lender can call the loan due upon the sale of the property. And that developed certainly back starting in the 70s and into the 80s, because lenders were getting hurt having below interest mortgages that they had to hold, and the borrowers were then selling the property to a buyer who would assume the mortgage or at least take subject to, and I'll talk about the difference in all that. But the due on sale clause, and it isn't talked about very much, but it's out there. Virtually every mortgage that you'll ever see, with the exception of some VA and some other kind of real consumer-oriented mortgages, will have a due on sale clause, meaning the property, if the property is sold without the consent of the lender can call the loan. That's a big deal. I mean, because all of a sudden, what was something that you could just make payments on, now you're calling it due, and you've got a choice of, if the lender, is calling the loan, you can either do one of two things. You can either refinance it if you got to find a new lender who will and we can talk about that, or you can pay off the loan, or you could sell the property outright and pay off the mortgage. But contracts for deed were traditionally very popular because there weren't due on sale clauses in mortgages. Now there are, and so that cuts back significantly. As a owner of property, I'll state this kind of as a hard and fast rule. You should never sell property subject to a mortgage without addressing the due on sale clause. And if you get the lender's consent, if you can't get the lender's consent, then you can't sell it, because what happens, someone's going to have to, if the lender calls the loan and they can, who's going to refinance it? Is it you, the seller? Is it the buyer? Probably not the buyer, because the reason he's doing a contract for deed is because he couldn't qualify for a mortgage. So anyway, that's kind of in the background of all this. That's a practical concern, that you can't really sell property subject to a mortgage, because you can't sell it on a contract for deed, because the contract for deed will typically trigger the due on sale clause, unless the lender is willing to say, yeah, it's okay. Okay, so let's leave that aside for a little bit. We'll talk about it more. But basically, what's a contract for deed? A contract for deed is kind of like a mortgage, but it's a form of seller financing. It's someone who owned the property selling it to someone who is owning it and needs assistance with financing. Now, typically, the reason people buy in a contract is that they don't qualify for mortgage financing. Interest rates are too high, or their credit worthiness isn't good enough, or it isn't. Sometimes the lenders wouldn't loan on certain types of property. Now, I think that's not so much a problem, but they'll come in and say, I want to, let's deal with the situation where there is no financing. The seller owns the property outright, so we don't have to deal with a due on sale clause. So how does it work? Well, the seller and buyer enter into what's called a contract for deed. It's a relatively short document. It provides that the buyer is going to be making monthly payments. First of all, there's a purchase price. Typically, there's a down payment of 10, 15, 20%, or maybe sometimes less. And then the rest of the contract, the rest of the purchase price will be paid in installments, typically using a longer, like a 25-year or 30-year amortization. But unlike mortgages, most contracts for deed don't go out that far. Most contracts for deed have what we call a balloon, meaning that after 3 years, 5 years, 7 years, 10 years, by its own terms, the balloon comes due, and the buyer has to pay off the contract. And if the buyer does, it's an obligation like a monthly payment, but it's usually in a much bigger amount, because the way amortization schedules work, even after 5 years, you haven't paid off that much of the principal. You've paid, maybe 5% of the principal or something like that, depending upon what amortization schedule you have. And so there's a balloon, and that's the big difference with at least most conventional mortgages. Commercial mortgages have balloons. They're a 3-year term, 5-year term, maybe interest only. On commercial property, on retail, stuff like that. They usually don't. You can get a longer term mortgage. Usually, they're the insurance companies give the 30-year mortgage on commercial property. But most mortgages on residential property don't have balloons. That's kind of unique, actually, to the United States. Most other countries, including Canada, they don't know these long-term self-amortizing 30-year mortgages. It's kind of an odd duck to them, but it's kind of second nature to us here. We think, yeah, all right, you paid off 30 years and you burn the mortgage and you own it outright. So a contract for deed is a little different, because most people don't want to hold the contract paper, and it is a debt obligation. They don't want to hold it for 30 years. Willing to hold it, 5 years, 7 years, maybe even 10 years, but at some point there'll be a balloon. Okay, so that's one distinction between a contract for deed and a typical mortgage. In addition, the remedies by the seller, and who's also the lender, are much it's much more lender favored than a mortgage. A mortgage takes you 9, 10, 11 months to foreclose and extinguish all the interest and be ready to resell the property. Currently in Minnesota, you can cancel a contract for deed in as short as 60 days. And in fact, Minnesota is a little unique in that you don't have to go to court. You don't have a sale even. You just serve a notice, a termination notice. The sheriff typically serves it. And if the buyer doesn't comply within the specified 60 days, the contract is over. The buyer loses everything they paid and the seller keeps everything they got. The seller can't get any more, but it's one of the more severe forfeitures known to American law. But it's been that way for decades and decades and decades. It used to, in fact, be a 30-day cancellation back about 40 years ago. And then it was varied for a while between 30 and 90, depending upon how much down you'd paid or something like that. But now it's been 60 days. And so unlike a mortgage, which takes much longer to get the property back, a contract for deed you can get the property back, or at least cancel the contract in as short a period as 60 days. Now, like a mortgage, just because you've exercised the lender's remedies doesn't mean you can just walk in there and throw the occupant out, the contract buyer out. You need to bring an unlawful detainer. You still can't use self-help. It's like the end of it is like a lease, because you got to go in and get an eviction order like you would for just if you had a regular tenant. But you can terminate their property, their interest in as short as that 30 days, or 60 days. Unlike a mortgage, which requires a 6 weeks publication, then you schedule a sale, and then there's a 6-month redemption period. So it makes itself more advantageous to a seller who said, gee, I don't know if I want to sell to this party in finance when it may take me 9, 10, 11 months to get the property back, because their credit may not be good, or their down payment may not be very good, or they've had other financial problems. So that's always a concern. But in fact, that's the primary reason people will sell on a contract for deed, whereas to people who can't get a mortgage, the alternative is typically a mortgage from a third-party institutional lender, a bank, a credit union, a savings association. In theory, a seller can also take back a mortgage, but that's rarely done because a contract for deed is so much more attractive. And it's so much more beneficial from the seller's standpoint. Okay.
Is it possible that people don't always have necessarily bad credit, that sometimes maybe they don't want, so a contract for deed doesn't show up on your debt to income ratio. You can close it.
Yeah, I suppose it couldn't if you don't tell someone, but I mean,
Right. It's not going to show up on your credit report.
it typically doesn't. Most most sellers don't. In fact, that's some buyers would like it to, because part of the reason, the idea that you're going to be able to pay off this balloon is that, my credit's going to improve, and so I'm going to diligently pay down, and I'm going to show I can, I'm a good credit risk, and now I paid off for 6 years on my contract for deed, and therefore now I'll qualify for a mortgage. You may or may not, but I mean, I suppose, it is a question. It's no different than a mortgage in terms of it's a debt. It's a debt of the buyer. Excuse me just a second.
You
So-
okay?
Yeah, I'm sorry. Okay, so that's the basic structure of a contract for deed. It's it's a substitute for the mortgage that most buyers can't get. It provides an advantage for a seller. They can, they know the property, and they're willing to. It's an investment for the seller. They're going to get a return, and they know they can, in a relatively easy way, be able to get the property back. Whereas, it's one thing to let someone in and say, "Oh my God, I won't." What could they do to the property in 10 months? As opposed to, well, gee, 2 months isn't that long. I can, I'll be able to get it back in 2 months. So it's an alternative financing device. And in Minnesota, we allow, other states don't necessarily do it this way. They require that contracts for deed be foreclosed like a mortgage, or that you go to court. Minnesota, and actually, interesting enough, Iowa is very similar. Iowa has actually a 30-day cancellation period, and they have a very similar procedure. All this requires is serving a 4-page notice. It takes a lawyer a little bit of time to fill out, and you serve it on the buyer. Personally serve it. There's a way of serving by publication if you can't locate the buyer. And then that extinguishes the contract for deed, and then you're free to resell the property to a new buyer. If that buyer didn't work out. There was a question here in the chat. Let me just take a quick look at that. It says, I'm going to just read it out loud. What tax advantages are there for a seller when selling on a contract for deed? Seller have to claim 100% of the sale, or is it parceled out over the term until the balloon? I am not a tax lawyer, and in fact, I don't rely on tax advice, but you can on occasion get deferral of the gain over a period of time by taking in installments, and you may not be, and I can't remember how many years you can spread it out. It may or may not be over the entire period, but that is one advantage. Of course, one thing you want to do though in that situation is you want to make sure the buyer can't prepay the contract, because if you get the buyer says, this is such a good deal, I'm going to pay off, then you'll get the whole proceeds. Now, a typical our form of contract for deed allows full prepayment. So if you were trying to get some tax benefit by not receiving all the payments or deferring some of the gain, then you'd have to write in the contract that it's not prepayable. It's only prepayable on such and such terms. Another
Reed,
question.
did that answer your question? My understanding, I'm not an accountant or a tax attorney either, but my understanding is you're taxed on what you take in that year.
Yeah, I mean, basically that's it. So if you can defer it off, and it's the principal portion that you do. Okay. Okay. Then the next question was, how did the nuts and bolts of contracts for deed work? Are there companies that administer them so that property sellers do not need to collect payments? Well, the nuts and bolts are fairly simple. The standard form Minnesota contract for deed is 4 pages, and you can fill it out in about 10 minutes. It's very simple. The only things that vary are the parties, what the purchase price is, how much down, what the interest rate is going to be on the. So filling it out, but normally, and I think a lot of real estate brokers are experienced in this, and they can help fill it out, or lawyers will do it from time to time too. So filling out the form. Now, regarding the actual process of getting the payments, pretty much in all cases that I ever see, the seller is going to be accepting payments, and they're going to have the payments, and they're going to want to see those payments every month, because they're going to know if the buyer's defaulted. Because if the buyer is not making the payments, they want to take their remedies. There may be outfits out there that will kind of administer it, but it's relatively simple. It's one payment, one each month, and it's like, I guess if instead of having 4 tenants, you have one contract for deed buyer.
And you could also make it a stipulation that it's like a automatic, you automatically suck it out of their account every month.
Yes, you set it up for that. I think people will structure it that way. Yes, you definitely can do it that way. So to avoid the word. Title companies do not get involved in, as I know this question is asked, well, gee, won't the title company just process the payments? No, they'll facilitate the sale itself, but they do not, they're not in the business of collecting payments. I suppose, if you hire a realtor for the sale, they may have part of their services. They might be willing to do, just administer the collect the payments and such. But
no, I don't know any of us who would do that.
I don't know that they do. I'm just speculating. I mean, it's very rare. I don't see the situation where, every month buyer makes payments to seller. Buyer makes payments to seller. Once in a while, you'll see, at least on some contracts, that there are some deferred principal payments, meaning that you'll have the down payment, but then you'll have, like once a year, you'll have an additional $25,000 that's written right into the contract. That's not typical, but that that's certainly permitted.
I bought on a contract once, where the seller, one of his criteria was he wanted principal reduction payments every year of a certain amount, because he wanted to take that tax liability that year.
Right. Yeah.
Yeah. So it's a contract that 2 parties, you can negotiate whatever you want, basically.
Exactly. Yeah. Yeah. And I would certainly urge anyone who's selling a contract for deed, if they've got any tax considerations, talk to your accountant, because I can tell you the legal framework, but I'm not giving any tax advice. I don't, and if I have any tax questions, I have to ask everyone else. I'm the last person I ask for tax advice. So,
just high level for a place to start digging. It sounded like perhaps the income you would claim would be only on the principal reduction and not on the interest.
Yeah.
Right. Okay.
Yeah, I think that's, because the interest is interest. That's ordinary income. You take that as ordinary income, and then and of course on a 30-year amortization, there isn't much principal you get for the first few years. It's very, very limited. First 5, 6, 7 years or longer. Okay, so
can I have a
yeah.
Okay, so my son and I just bought a duplex up in Hayward on contract for deed.
Oh, in Wisconsin, yeah.
Yeah.
Wisconsin has a slightly different law in terms of the remedy. I think you have.
Well, that's not really my question.
Yeah, no. I want to say that the remedies I'm talking about here only apply to Minnesota. So
okay, well, we're the buyers.
Remedy question. What I'm talking about won't be applicable. difficult, but I understand. Go ahead.
Okay, so now the thing that I just didn't, I mean, it just occurred to me the other day. So the property only cost $145,000. So it's a 10-year, a 12-year contract for deed.
Okay.
Now, what I was thinking the other day, if we get in a situation where we want to sell it, we can't, right?
Well,
How
it depends if there's well, first of all, it depends. You mean cashing out your whole interest or transferring the
well, because if I mean, so I bought it with my
the
son,
contract?
and what if he
Yeah, it's two
decides not to live in
different
Hayward anymore? Then we've got this property up there. Then we may just forfeit our whole thing. I mean, we're not in a position where we have something we could sell, right?
Sure. Yeah, no, a contract for deed owner is the owner of the property virtually the same way a mortgagor is the owner of the property. We sometimes say that, oh, the bank owns it. Well, the bank doesn't really own it. If you've got a mortgage, you own it. You're responsible for maintenance, taxes, and basically, and if the value goes up, you're going to benefit from that. If the value goes down, you benefit from that. A contract for deed buyer is the functional equivalent of a mortgagor. So, and unless there's some provision in the contract, which again is pretty untypical, that prohibits prepayment, you can always sell that property.
I think it does. I think we have he said we couldn't pay it off for a minimum of 8 years.
Is that in the contract, Pam?
I'm pretty sure.
I mean, then you may need to negotiate something with them, but yeah, they're looking for some tax benefit by restricting prepayment, and prepayment prohibitions are permitted.
Okay, so if we got into some situation where we would need to sell it, we would have to work.
Well,
the right?
alternative is having someone selling out your equity to someone else who take over the payments on the contract.
Oh, so you could do that.
It depends. It depends on how the contract is written. Sometimes there's anti-assignment clause. I was talking about due on sale clauses in mortgages. There's sometimes anti-assignment clauses in contracts for deed. But what you can't do is you can't say, well, no, I'm gonna call this loan because you sold it, but there's no prepayment. You can't have your cake and eat it too. So,
right.
So, I mean, you can get stuck, with a prepayment, and selling on a contract may not be the most. Selling, that interest in the contract may not be the most valuable, but generally, one way or the other, you can get out. It's not like you're frozen in there forever. That you've got an investment that's not liquid.
Okay, so I just need to read the contract, but we're not.
Yeah. Take a look at the contract.
Or have to walk. Because he's kind of a slumlord, is what we found out. So my guess is kind of way he's kind of taking advantage of people as he's doing this and then taking their 20% or whatever.
And did you have a pretty good sized down payment?
Well, 20%. I mean,
that's a pretty good. So you're kind of married to it, yeah.
I mean, it's only $145,000 property. Yeah. I think we have like 30,000 or 24,000 into it or something like that.
Okay, so let me just talk about briefly, just because I alluded to it earlier, what to do about where there's an existing mortgage on the property, and there's two ways you can handle that mortgage with a contract for deed. And again, in both cases, it assumes that the lender is saying, yeah, it's okay. I'm not going to call the loan. I'm not going to exercise due on sale clause rights, because I'm not going to call the mortgage and make it all due, which makes everything fall apart. You got to refinance everything then. So what is sometimes done, but isn't done very much, is called an assumption, where the buyer on the contract for deed simply assumes the obligations on the senior mortgage. They make the payments directly to the lender, to that lender. They may also make some separate payments they'll also make some additional payments to the contract for deed seller, to buy out the seller's interest, because, give you an example. Let's say it's $150,000 property, there's $100,000 mortgage, and they buy it for 150. So they assume the $100,000 mortgage, they make the payments directly to the mortgage company on that 100,000, and then on the remaining 50, the buyer would make payments just to the contract for deed seller on that 50,000, with interest that would amortize and balloon and have its own terms. So, but that's not the typical way you see it nowadays. Now it's much likely to have what's called a wrap around contract for deed. Wrap is in Christmas wrapping. And what that means is that there'll be an existing mortgage there. And again, I'm going to leave aside this issue of the due on sale clause, assuming that there isn't any issue. But let's say in the example here, let's say the mortgage is for 100,000 and the property is sold for 150. Let's say there's no down payment. Let's just keep it simple. So the contract buyer will make payments to his seller on principal and interest on the 150. But the contract seller will then take a portion of those payments and send them upstream to the mortgage company, because the mortgage company's got to get paid too. So what has happened is that the contract for deed has wrapped around the existing mortgage, so that the buyer only makes one payment to the contract for deed seller, who then services the mortgage. And that's the wraparound contract. Now, that's advantageous to the seller for a couple of reasons. One, because the seller knows where all the payments are going. They don't have to wait to find out from the mortgage company saying, oh, that buyer of yours, they haven't made payments for 3 months. Did you know that? And if it was an assumption, you may not know that because you're not getting those payments. The payments are going directly to the mortgage company. Whereas with a wraparound, all payments are going to the contract for deed seller, and he'll know right away whether those payments are being made. The other reason that they do a wraparound contract is that typically the mortgage, well, let's say it's at 4%, and your contract will be at 7%. So not only is the seller getting 7% on the money above the mortgage that he's in effect loaned, but he's getting the differential, the arbitrage between the 7% and the 4%. On money he's never advanced, he's just taking advantage of the lower interest mortgage, and he's profiting from that, and that's done quite a bit.
So that doesn't trigger a due on sale clause. Is there a?
Well, it won't if the lender says, I'm not going to call the loan if you'll allow you to sell, but they may or may not. Now, if you're the mortgage company, you may say, oh, geez, I'm only getting 4%. I'd rather get this loan called, get it paid off so I can reloan at 7 or 8%. So you may have that problem. And the subject doesn't come up very often, but you've got to make sure that you aren't selling in a way that'll trigger the due on sale clause. Sometimes people will do it intentionally, and what we call that a secret sale or a silent sale. And it happens very rarely. I always ask people, do you know of any secret sales? What they'll do is, because let's say it's hard to get financing, they know the lender won't consent to a contract for deed sale because the lender wants to get rid of this loan. So they just don't tell them. All the payments go to the seller. The seller continues making payments like they always did. They keep the insurance in the seller's name. They don't record the contract, so the tax statement doesn't reflect the new buyer, and they do it on the hush-hush. From a legal standpoint, it's playing with fire, and I know of no lawyers who will. Most lawyers won't even touch a transaction like this because it's so dangerous. What happens if the lender calls the loan? Well, I guess, maybe the seller's supposed to pay it off. Well, what if the seller can't? Well, the buyer can't get a financing. So, you're gonna have fingers pointing and no one's able to bring in a new mortgage, which is the only solution once the underlying seller exercises the due on sale clause. The only way you can do it is just refinance. And if the people aren't, if refinancing isn't a feasible option, then someone's going to lose that equity, maybe both parties, because the lender will take it, foreclose it, and it's gone. As my mentor used to say, the land is gone, it went to land heaven.
I had read ages ago, and I should have reread it, something about you could set up a trust to avoid the due on sale clause.
Now I don't want to get too much into the weeds, but actually you raise a very good question, because under federal law and all the due on sale clauses, 30 years ago, we were fighting about whether due on sale clauses were enforceable. My firm represented borrowers. We said, no, it's a restraint on alienation. Lenders shouldn't be able to do it. Eventually, the federal government got involved, because this is in part what killed the S&Ls. They didn't have due on sale clauses. They got stuck with all these low interest mortgages and couldn't get out of them. So all the lenders, all the institutional lenders started putting due on sale clauses, and the federal government passed a law that says due on sale clauses are enforceable and they override any state law restrictions. So due on sale clauses are in mortgages are clearly enforceable. What the federal law did do, however, is they created a few exceptions for family transfer, and there in fact is one if you put it in trust, but the beneficiary of the trust has to be the occupant of the property, who the original mortgagor. You can't do it. It won't work. There's nothing much new under the sun. There isn't a good way of avoiding it. I mean, you gotta see if the lender will allow the transfer. Just using a trust isn't going to do it, because there is an exception for a trust, but it's for a personal trust of the seller. I own my property. For estate planning purposes, I want to put it in a trust. I'm going to just put it in the Larry Wertheim Trust for benefit of myself, my wife, and our kids, and whatever. But I'm going to continue to occupy the property. Well, that's not a transfer that triggers a due on sale clause, but a putting in a trust for a beneficiary of Jimmy Schmidt, who is just a unrelated party, who now will get the benefit of the use of the property, that's not going to avoid the due on sale clause if the lender finds out. Again, sometimes people do secret sales. Okay. All right. So we explained the two different ways that you can deal with a pre-existing mortgages, assuming you don't have a due on sale problem. The basic idea of a contract for deed is that the buyer comes in, the buyer is entitled to exclusive possession. They have all the rights, the same rights as a mortgagor. They have a right of possession, they have a right to lease it out. They typically have the obligation to maintain the property. They'll have the obligation to pay taxes, and they'll have an obligation, and typically the contract for deed will require the buyer to maintain insurance and cover the seller as an insured party, in case of casualty or something like that. That's kind of the let me step back here for a second and give you some well, I don't want to call it inside information, but there's likely to be a change in Minnesota contract for deed law coming up in this new legislative session, and it'll affect residential property up to 1 to 4 family homes. Now, it doesn't prohibit contracts for deed sales, but it will mean that it's going to be more complicated to do it. You're going to need to do some more disclosure to buyers. There's been a few bad situations where people have bought some real high-end properties from investor sellers, meaning that they came in, they bought it from an underlying buyer, and then they resell it, they turn around immediately and resell it on a contract for deed. Nothing wrong with that, perfectly legal, but there's been some buyers who didn't really realize what they were getting into, put down significant monies on high-end properties and are facing some, loss of all equity. And so there's a concern, and there is a statute right now if you sell 5 or more properties in 12 months on a contract for deed, which is kind of what we're talking. This may be a little bit more expansive, but if there's, it will require certain disclosures, and there'll be certain remedies that, so it won't be as easy as it is right now. For any of you folks to sell on a contract, you just need a willing buyer and someone who draft up the contract, and you give them and there's even, you may or may not record it. It's very simple. It would get more complicated by next year. I just give you that as simply because I am familiar with what's being currently proposed, and it won't prohibit those sales, but if you really are interested in it, you should do it now in the next several months rather than waiting a year or two, because it'll be more complicated. It won't necessarily make it, prohibit you from doing it. It'll just be a little bit more complicated. That's all.
Is
So-
that something going before the legislature, or?
Yeah, you'll probably read about in the paper, and you may have seen some stuff about contracts for deed. There was an article in the Star Tribune and the Attorney General looking into things. There was some, but yeah, it would be some new legislation.
Is that different than like rent to own?
Yeah, it has nothing to do with rent to own. It's dealing with contracts for deed of residential property.
So I was at a meeting about a month ago, and somebody proposed, so, if you take payments over, say, 5 years, then there's a balloon, there's, you can't, it was basically, you kind of got to take it, there's no advantage to that balloon.
To the seller?
No, I'm trying to think of how to phrase it, that
Well-
you could do a rent to own
Yeah.
to take advantage of, the gain in a certain year instead of a contract for deed was what.
Right, a contract for deed fixes your gain at the time of sale.
Right.
And rent to own. And again, I'm vaguely familiar with it. I don't see much of it, but I think that's even more potentially onerous to the occupant than a contract for deed. A contract for deed is an owner; they're an owner, and they got certain protections as owner. Whereas rent to own, you're just a tenant, and you have less protection as a tenant than an owner. So. And I don't know anything about it, but I wouldn't be surprised if there's legislation dealing with rent to own too. I know nothing about it. It's nothing I've looked at all. So, but I mean, the concern there was concern because it's a very severe remedy. After 5 years, you don't pay that balloon. Everything you paid is kept by the seller. No questions asked.
Now, one of the things I hear from sellers, because I sometimes suggest that this might be an option to mitigate some
Sure.
taxes, is I don't want the property back.
Yeah.
What you're saying is you get the person's down payment, you get all their payments. How much damage could they do? You turn around and you sell it again, and you get another down payment and all of the next person's payments if you get it back.
Yeah. The one thing you gotta avoid is churning. doing it where you know the buyer can't make the payments. And we've got some old law in Minnesota, and it's a concern. Now, there's no duty to investigate. There's no duty to do underwriting. You're not subject to all these fancy rules about what lenders have to do and look at credit scores and stuff like that. But that's part of the concern, was that, yeah, people were selling it repeatedly on a contract, and it wasn't, and the buyers didn't realize what they were getting into.
Okay.
I mean, in theory, contracts for deed are a marvelous device. They've been around in Minnesota for over 100 years. They allow people to buy property who can't otherwise afford it, who don't qualify. Their income is irregular. They don't have, they own a business, and it allows people to own and to get equity in an appreciating market. It works. It can work wonderful, but it can get there's some downsides to it, and losing all your equity in 60 days is a big deal.
Right.
But that says, all right, seller will let you in, because how bad can it be after 60 days? Whereas I wouldn't give you a mortgage on it, and you couldn't get a mortgage because you don't qualify. So it's, in a way, it's kind of a poor man's mortgage in certain contexts, or
Right.
or someone who's and that's why I think it's very important to try and protect the device, because it allows people, it's a form of seller financing that makes available home ownership or property ownership that people wouldn't otherwise qualify for.
If we put the shoe on the other foot and you're a buyer, are there certain things that you want to make sure are in a contract to protect you?
Well, yeah, I mean, sure. Well, part of the problem, of course, is if you're a buyer, no lender will make a loan unless they get an independent appraisal, right? They say, oh, you're paying too much for that. I can't give you a loan. We've heard of that.
Right.
I mean, it's not as all protective as you might think, but at least there's some licensed appraiser saying that nothing with a contract for deed. You have no idea if the price you're paying makes any sense, and maybe that seller bought it the same day for $100,000 less. You don't even necessarily know. So there isn't, and if you paid too much, you're going to have a heck of a hard time refinancing it when the balloon comes.
Right. So you probably would want to make it contingent on an appraisal.
You might, yeah. Buyers would, but in
Sellers
most cases,
don't.
I don't think they typically do. I think they almost never do.
Right.
It's, I mean, it adds a cost to the buyer. It's closing on a contract for deed is really cheap. There's hardly any cost. There's no deed tax. It's $46 to record the contract. Unlike with a mortgage, I mean, you all see it's 1 or 2%. I mean, you got the appraisal. Most people probably should get title insurance, but they don't. But but if you're dealing with a third-party lender, they're going to insist on title insurance, and you're going to pay for that. Whereas most contracts, I don't know, but I suspect a lot of contracts for deed, close, and the buyers don't get title insurance. Now, whether they have problems later on, I don't know. But in theory, there's a okay. So here's our question from the buyer's perspective. Is there a specific thing I should watch out for? I'm in the process of looking to buy and considering contract for deed, worried about making an expensive mistake. Well, yeah, I don't blame you at all. I mean, when I first heard about contracts for deed in law school, I was astounded at saying, really, you do this? I mean, from a buyer's perspective, saying that, and it's canceled like that. Well, yeah. And back then it was a 30-day notice. But you know, I mean, you know, an appraisal is a good idea. You know, making sure you understand. I think the biggest concern is buyers not understanding the balloon, because, you know, you can, you know, typically payments on contracts for deed, it's not amortized over the 10-year period that the contract's in effect. The payments would be way too high. They amortize it over 30 years, so you get payments that, you know, comparable to what you would with a mortgage. But the problem is, of course, you've got a balloon, and you've got to understand, well, what's the risk of, you know, but I think in that many years, I'm going to my finances are such, I'm going to be able to qualify for financing that I couldn't qualify now. I'll have been in my job X years, et cetera, et cetera. So, I mean, you know, really understanding the balloon and understanding the shortness of the cancellation. Got another question. Isn't state deed tax due at the time of the balloon? Is it ever collected upfront to make sure it gets paid? Well, there's no state deed tax due on the contract for deed. The state deed tax due is the balloon, and we've kind of said what the balloon is, but maybe I wasn't clear. The balloon means the remaining principal is due, and if you pay it, the seller's got to give you a deed, saying the contract's paid off, and the deed, and then you record the deed, and yeah, I suppose you might want it's an obligation of the seller to pay the deed tax. And in fact, what they typically do is the buyer simply gets a credit on the remaining balloon for what the deed tax is, because it's the seller's obligation. So there's a source of payment there. It just offsets from what let's say the deed tax is, you know, $2,000. I'm making something up, but the balloon is 50,000, so you'd pay him 48 and say, all right, give me the deed, because you know, you just get a credit for the deed tax that's going to be paid for the closing. The next comment here is watch out for the prepayment penalty if there is one. And I don't see many, you know, as I said, the standard form in Minnesota allows full prepayment without penalty, no restrictions. I suppose sometimes there are prepayment prohibitions or penalties or premiums. And if there are, yeah, then you really have to watch out for that. And there's an addendum that sometimes gets used that does have a prepayment premium or prepayment prohibition. But I guess all I can say is that, I mean, you know, if considering buying on and people will buy rental housing on a contract. They'll buy it on a contract, and then, you know, and it's now an investment that they have, and they collect the rents, etc. So there's nothing, you know, inherently wrong. But again, it's, you know, it's the form of financing, and if you think it's you know, if you can handle the balloon, and if you know when the balloon's coming, you know, the balloon's not a surprise. You know from the date you enter into the contract when that balloon is. So, you know, if you need to set aside money, but the problem is most people can't afford to pay the balloon. The only way you can pay for a balloon is either refinance the whole thing with a real new mortgage, or sell it off and sell the property and get enough cash, you know, and take out your equity, and some new buyer gets new financing entirely. But that's typically how I think, you know, rarely does a buyer say, oh yeah, I got enough set aside here to pay off the balloon. It's a humongous amount of money, you know. I mean, it is, even after 5 years, you pay 10% down, you probably amortize 5%. So it's 85% of the purchase price is going to be due. That's a you know, big balloon.
I actually bought a couple of small apartments on a contract for deed, and that deed's coming due in the spring. So you imagine when I bought it, interest rates were low. Now
Yeah.
it's difficult to get financing.
Yeah,
Interest rates
I mean,
are high. I've been
yeah.
sweating bullets. I called the guy
Yeah.
and just asked him if, and he said he'd extend me for 2 more years at the same
Right.
rate. So I got really lucky, but I'll
Yeah,
tell you
and
what,
that's
there's the last couple months I've been really nervous.
right. And you're absolutely, and that's exactly what you do. And sometimes you'll even put in a little spiff saying you won't increase the purchase price, but you'll say, look, as an extension fee, I'll pay you X dollars, to give me that more time because, if, your only alternative would be to just cash out the whole thing and assume you can find a buyer, but it's coming up quick and who knows, who knows if there's a buyer out there for this particular property. And if mortgage financing, it's subject to all the risks. But it's allowed you to buy the properties in the first place, and it sounds like maybe hopefully interest rates go down, and maybe you come out okay. But you wouldn't be in this business if it was simple, right? Any other questions?
I see one from Martin that, how do you find contract for deeds? Just need to ask around. He says from looking online, most listings are connected to a realtor. As a realtor, I want to speak to that.
Yeah.
A realtor has nothing to do with whether or not the seller will accept a contract for deed. Not at all. In fact, I've had several sellers or prospective sellers lately tell me they would be open to it. And there is a box that we check when we put the input form into the MLS where it says the seller will consider that kind of financing.
Because it expands the universe of potential buyers. I mean,
well, and it gives as rental property owners, it gives rental property owners an opportunity to do some tax planning, especially if you're at the point in your investing life where you just don't want hands-on investment anymore. You want to be done. But I've had sellers who've between capital gains and depreciation recapture, experienced as much as 47% they owe to the IRS.
Yeah. And
so this is a way to offset some or all of it,
So, Carrie, how do you get paid on that? Does the down payment cover your commissions then? So you do
it's got to cover closing costs, and that's all negotiable.
And I think there's a misunderstanding with the consumer that contract for deed means no money down.
Yeah.
And it doesn't mean that. And I haven't met too many sellers who'll just turn over the keys and not expect a down payment.
I tell you, there is one special rule with contracts for deed. Basically, if you cancel, the seller gets to keep all that was paid over, but they can't get any more. Even if the buyer committed waste on the property, you can't sue the buyer for waste. You can't, so it's such a tough remedy, but that's all you get. There is one exception, however, in Minnesota. We have something called a down payment note, so that if the buyer gives a promissory note in connection with the down payment, and if it isn't too large in comparison, and it looks kind of like a down payment, and it kind of substitutes, it's got kind of like the price of entry, and the seller subsequently has to cancel, as long as you put the proper verbiage in that note, the seller can sue the buyer on the note. That's the one exception to what we call the anti-deficiency rule. They can take a promissory note and it will survive the cancellation, and the seller can sue the buyer on it. Now, most sellers aren't going to bother with it, because who wants to chase someone on a promissory note, unsecured promissory note? But it's oddly enough, that's kind of a reflection of the fact that it's true. Contracts for deed typically most sellers are willing to take a less than, it's not like you got to have 20% down, which I think nowadays virtually all mortgages require. Well, contracts for deed, you can get by with a little less, and it's all negotiable.
But if you're buying and there is an agent involved, the agent is going to probably have to be compensated some way.
You got to get a sale somehow. There's transactional costs. Absolutely. No, I mean, there's no free lunch.
No, and I'm not gonna, as a realtor, I'm not gonna bring a buyer. I'm not gonna work for a buyer for free, right? I have gas into it. I have time, and
No, I mean, in fact, a contract for deed transaction probably is even more work because you're gonna be kind of, I mean, if they're going out to get a mortgage, you just, all right, yeah, I got pre-qualified and yeah. But contract for deed, there's, you're gonna have to probably work a little harder.
Negotiate some of those terms of financing.
Exactly. Yeah. I mean, and I think and brokers will sometimes end up having to draft the contract for deed too. Sometimes, I recommend lawyers do it, but, I mean, it isn't brain surgery. That part of contract for deed law is not complicated, but you just got to make sure you get it right. I mean, I've seen some kind of homemade versions where they actually, it was two parties, they didn't even have a broker, and the verbiage is not well done. And so it's not something you should do. It's not something you should practice on at home. Someone knows what they're doing has got to be drafting it. Let me see. Anyway, I guess so. It sounds like people have had some experience with both buying and selling on contracts for deed. Have there been many sellers in this group? Anyone selling on contract and any experience?
I just as an agent, I've been,
Yeah.
right. I've been mentioning it with my sellers just because
Yeah.
it could be an option with interest rates being what they are right now.
Right. I mean, the problem, of course, the biggest problem again is the due on sale clause. If there's a mortgage.
Sorry, do your sellers then own the property outright?
No, that's not an issue. Again, due on sale clauses only if there's an existing mortgage. You own it outright, you can sell on a contract for deed in a heartbeat.
Some of them have a small mortgage that they may be willing to pay off
Right. Yes, that's
in order to avoid that.
Yeah,
Okay.
yeah, that good point. And or yeah, or it may be so small that the seller says, yeah, I'll pay it off, in the next few months or something. It's such a small amount that the seller can, and the seller is taking responsibility. Sometimes these things get worked out that way.
I'm talking to many long-term owners, right now. I've got one duplex coming on the market in January where it's been the same owner for 40 years. So she's depreciated everything.
Yeah. Oh yeah. I mean, it's
Yeah.
And that, I mean, if you're looking, I mean, it's a secure investment. It really is. I mean, there's insurance. I mean, sure, there can be damage to the property, but it's such, it's not like, you can move pretty quick, and and the buyer is going to be incentivized to make the payments. I'm glad to hear actually that that at least there's some more talk, because there's a limit of, is anyone, I take it no one has really been in bought property outright with a mortgage loan and then sold on a contract for deed. What I call an investor seller, who's just come in, who had no previous contact with the property, but came in, bought it, and it looks like a good investment, and then sells it on a contract.
I know I have an agent friend who's involved in a transaction like that right now. They're actively looking for it's like the investors there.
Yeah.
And they're trying to find a property that the buyer likes, and then that's the plan.
And they got, and of course, what the investor really, he brings the ability to get financing. That's why he's in the deal, because and without the deal wouldn't happen if you didn't have an investor with good credit that this lender say, yeah, sure, I loan to them all the time. Another loan on the books. Well, you've got my contact information. Oh, let's see, just a second.
You want to put it in the chat, Larry? So if
Yeah.
anybody
Is selling on a contract for deed while seeking a 1031 exchange doable? No, you can certainly sell on a contract, do a 1031. It's just that you've got, well, the question is, and again, now we're about to exhaust my 1031 knowledge, but so
I think that's the person I talked to about the rent to own.
yeah,
it would be hard to exchange because you'd have to exchange, as I understood it, and tell me if this is
Yeah.
wrong, because the source, he could be wrong, but that you would have to exchange in that first, it would be the same as a regular 1031 on
Yes,
a,
oh, there's no
it-
different, it's no different. Yeah, and yeah,
right,
you
but
got
that if
that.
you structured
yeah.
it as a rent to own instead, making maybe the terms the same, and then, year 5 or whatever, then they could buy it. But you're right, what you said earlier, that the buyer wouldn't have ownership rights. in
Well,
that
yeah,
year.
and there's no 1030, you can't, yeah, I mean, yeah, I mean, you gotta have an actual transfer, and, you gotta apply all the proceeds, you have to go towards the, replacement property and all that other good stuff. But, I just have not seen that many 1031s, using a contract for deed, but, in principle, it doesn't really, shouldn't really apply. But I mean, I think from a, if you're tired, if you're tired of collecting rent, from your 4 tenants, and and you're able to get some good tax advantages, it sure makes sense to turn this into just a regular investment and to sell it on a contract. So, again, and again, being willing to sell on a contract expands the universe of your buyers, because there's people out there who can't get financing, who would, who can't, would love to buy your property but can't get financing. If you're willing to finance it with a contract for deed, then you're able to get a buy, do a transaction where maybe you couldn't have done one. So, any other questions here?
Larry, did you put your contact info in the chat?
No, I didn't. Let me do that. Hold on. Hold on. Let's see. Okay, let me just, and I'm just gonna, let's see. I'm just gonna give you my cell phone number. Well, I'll give you an email address too. Oops, sorry, 582, and it's, oops, oh, sorry, I meant that. And then it's L. Okay. Yeah, okay, so you got my email, and glad that, talk questions. Again, it's not, again, talk to your accountant, because they're gonna give you the best advice, regarding your particular situation. I think a lot of this is driven by, the tax situation. So, all right, good. Any other questions? Enjoyed being part of this, and if occasions want to talk about another time, I'm always glad to talk about contracts for deed.
Well, Larry, thank you very much for your time. And if anybody has any questions, I mean, feel free to reach out to Larry and ask him. And of course, I want to wish everybody a happy holidays, whatever it is you celebrate. And we will get together probably mid to end of January, just because I'm traveling the first part of January. So if you have any topics that you would like to know more about, I'm happy to try and get a speaker. Does anybody have any recommendations or requests? Silence.
This was a good one. Thank you. Thank you, Larry.
You're very welcome. Yes, thank you,
Carrie.
Larry.
Okay, thank you. I appreciate it.
Yeah.
I can talk about contracts for deed till the cows come home. I
Yeah,
never.
thank you, Larry,
Being
and thank
surprised, and I always
you,
learn
Carrie.
something new. All right, very good.
All right, everybody have a great evening and happy holidays, and we'll see you in the new year.
Bye now. Bye-bye.
Bye.
Thank you, bye.